Culture is something that shifts slowly. The kind of shift that sees people turning to resolution, process, and supports is much more broad that can be achieved simply through amendments to rules of court and court announcements. It's a different way of thinking that affects many different sectors, organizations, programs, and at their heart, individuals. It's collaborative, which of course you are all familiar with through your practices. If there's still a demand for litigation, adjudication, and JDR in our community, I would suggest that this is because we are still working in a culture of adversarial processes where people are accustomed to turning first to the court. The court's not catering to or promoting adjudication over resolution processes. We're receptive to creative solutions which help to reduce litigation, and which we find are often presented to the court by counsel who are not regularly litigating in our court. We recognize that transformational change takes time, and we believe that the pendulum is swinging toward early access to dispute resolution processes, as demonstrated by the Family Docket Triage Project, the growing interest in ADR, and the growing understanding of the importance of family supports. I believe that when we align our efforts to a common goal, we're more likely to achieve the culture shift that is needed much sooner. We should all applaud the changes as they take place. When made in alignment, these are part of improving the way that families experience separation, divorce, and related family issues. You should recognize that as collaborative practitioners, you are actually leaders in the culture shift that is underway. Through the work that you folks do, your processes, your education programs for practitioners, they're all helping to ensure that families receive the supports they need that will lead to better outcomes for their children. Winston Churchill was working to form the United Nations after World War II, and he said, "Never let a good crisis go to waste." I mean, it's a tough message. And while obviously none of us would have wished for the global pandemic, it is true that there are some silver linings or gifts that have emerged from the dragon's mouth in this time of change. And Diana has often with us talked about the no smoking campaign. You know, how it took a lot of time to get people's minds wrapped around no smoking until it became a culture. And I just love that analogy because it does take time, but at the end of the day, we should all be thinking in terms of early and not the end date. So that's why I'm very appreciative of that suggestion. I'm actually conceptualizing it as a way the court will get smaller in family law matters and move as many as they can out. Essentially, we would like not to have them come in until they've been triaged, at least, you know, perhaps at the doctor's office, the local doctor's office, at a place like a center as in Strathcona County. And so people who actually come through the doors of the courts are aware that, you know, they're there for a reason. It may be legal by that point. So actually that's my long-term vision, is that we play a lesser role, because the role we play right now, unfortunately, is steeped in an adversarial tradition. And I think because, you know, we need to unblock that culture where family law matters are concerned because of the clear damage to children that conflict causes. That's actually my hope for the future, is where we become less relevant as a court in those areas. I'm not saying that there aren't areas. I mean, I'm not gonna take a job away from our judges, but in the family area, certainly the areas where there is a legal issue to determine, they are fewer. Now, I want to speak a little bit about the suspension of the ADR rule and this court's lifting of that suspension in September of 2019. That's when we began the one-year pilot project on essentially lifting that suspension. The pandemic has caused us to focus on statistics gathering in other areas. So I would have dearly loved to provide you with some statistics on outcomes regarding this pilot. But I do think that generally the lifting of the suspension has been accepted as a positive measure. For those matters that do have to go to trial, parties are not permitted to request a trial date unless they provide a certificate that they participated in a judicial dispute resolution. The CDAA made representations to the court seeking recognition of collaborative family practice as an ADR process that would comply then with Rule 8.4 sub 3 sub A sub 1. We made that adjustment and now recognize that collaborative law processes are an ADR process under the rule. We don't keep a list of designated ADR professionals who can sign the certificate that is required under the rule. However, a letter from the collaborative law professional outlining their credentials and setting out that an ADR process was undertaken in compliance with the rule will be accepted for the time being. Now, your association has suggested the possibility of front shifting the mandatory ADR or JDR to occur. And a very interesting proposal that was given as you submitted questions for this particular exchange today was that moment after financial disclosure has been completed, rather than waiting to closer to trial. I gotta say, I like this idea, and I'm gonna be taking that back to our court. It's a real pleasure for me to be able to chat with all of you. And you've heard a lot during this time about we're all in it together, but on this particular subject that we've discussed today, I think we're all in it together. Thank you so much, and everyone stay well.